Well, this is the document 207, which is the exhibit list that is accompanied with three of the filings yesterday. The first one being the subpoena submitted to Michael Griesbach to obtain information that he has. The other one was this, which I'm about to go through, and the third one was a new attorney being assigned to the Netflix case. But here we go. Lita Walker, under penalty of perjury, subject to 28 U.S.C. 1746, declare as follows: I am of the attorneys for defendant Netflix Incorporated in above captioned action. I personal knowledge of the matters set forth herein. I make the declaration in support of Netflix motion to compel production of documents responsive to subpoena to Michael Griesbach. Attached to Exhibit 1 is a true and correct copy of the subpoena to produce documents, information, or objects, or to permit inspection of premises in a civil action to Michael C. Griesbach, as served on Mr. Griesbach on February 10th of 2022. Attached hereto is Exhibit 2 is a true and correct copy of the objection to defendant's Netflix Incorporated subpoena to attorney Michael Griesbach, as served by counsel for Mr. Griesbach on Netflix Incorporated on February 24th. Attached hereto is Exhibit 3, a true and correct copy of the March 8th, 22 letter sent by me, John F. Meyer, counsel for Mr. Griesbach in this matter, regarding Mr. Griesbach's objections to the subpoena and seeking the opportunity to meet and confer regarding Mr. Griesbach's objections. Attached hereto is Exhibit 4, a true and correct copy of email correspondence between myself and Mr. Meyer regarding the scheduling of counsel's meet-and-confer, as well as correspondence exchange after counsel's meet-and-confer. Attached hereto is Exhibit 5, a true and correct copy of email correspondence produced by Manitowoc County Sheriff's Department in response to subpoena served by Netflix Incorporated, Bates stamped Manitowoc 016498. Attached hereto is Exhibit 6, a true and correct copy of the document produced by Manitowoc County Sheriff's Department in response to subpoena served by Netflix, Bates stamp Manitowoc 000065068. And attached hereto, Exhibit 7, is a true and correct copy of the email correspondence sent by Mr. Griesbach per producer of the defendant's Laura Riccardi and Mona Demos, which I obtained from counsel for the producer defendants. Attached hereto is Exhibit 8, a true and correct copy of the experts from the depositions transcript of September 22nd, 2005, Mr. Griesbach versus Avery Manitowoc. I declare under penalty of perjury the foregoing is true and correct. Dated March 22nd, 2022, Lita Walker. Exhibit 1. Subpoena documents, information, objects that permit inspection of premises in a civil action. You are commanded to produce at the time, date, and place set forth below the following documents: electronically stored information or objects, and to permit inspection, copy, and testing, sampling of the material. Place: Godfrey Kahn, James Friedman, March 11th, 2022, 10 a.m. Federal Civil. I'm not going to read all of this. I'm going to attach the document to this in the comments or description when this is done. Exhibit A. Pursuant to this attached subpoena, you are commanded to produce the following documents: electronically stored information, tangibly things in your possession, custody, or control. Definitions and instructions. The following definitions and instructions shall apply to the document request herein. Notwithstanding the definition below, each word, term, or phrase used in this request is intended to have the broadest meaning permitted under federal rules of civil procedure. Instructions. You are obligated to produce all responsive documents in your possession, custody, or control. This means that you are obligated not only to conduct an adequate search for the responsive documents that you are currently possess, but also to make the same fulsome search for all responsive documents that are in custody or control. This obligation requires you to search for all responsive documents that you have a legal right to obtain from any source, including documents that are currently in possession of third parties. such as bankers, accountants, physicians, attorneys, agents, representatives, employees, or government agencies. If you cannot respond to any document request in full after exercising due diligence and secure the requested information, so state and answer to the extent possible, specifying the reasons for inability to answer the remainder and stating whatever information and knowledge you have concerning the unanswered portions. If any document or portion thereof which falls within the scope of the requested documents is withheld from inspection or production, the document or portion therefore shall be identified as the reasons for withholding such documents or portion thereof shall be stated. The identification of the document or portion thereof shall include the date of the document, the author or originator of the document, the person of the entirety to whom the document was addressed, the name of each person and entity who was provided with the copy of, had access to, or examined the document, the type of the title document, general subject matter of the document, present location of the document, name of the custodian thereof, for any document which is subject to a claim of attorney-client privilege or attorney work product. The grounds upon which claim or privilege attorney work product is made shall be stated. In accordance with the provisions, requested documents shall be produced as they are kept in usual course of business or shall be organized to correspond with the categories in the request. In accordance with the provisions, document requests calls production and electronically stored information. You should produce the material in both PDF or TIFF image format with the document control number associated with each page of such images, as well as the native format of the material, so that all associated metadata is also produced with the electronic file. Unless otherwise specified, each request calls production documents created on January 1st, 2002 and before October 1st, 2018. Attached here to it, Exhibit B, is a true and correct copy of protective order entered in the court action for reference. Definitions: it uses a singular form of any word, includes the plural, vice versa. The words and or should be construed conjunctively or disjunctively. The necessary to make discovery requests inclusive rather than exclusive. The terms each and any. I'm not going to read all this. This is just this is a bunch of stupid. Document requests. All documents drafted in connection with the books, whether formal or informal, including outlines, treatments, draft, final manuscripts. All documents, communications which consulted, relied upon, sent, received, or used in writing the books. All documents, communications regarding, related to, including, consisting of any drafting, editing, or fact-checking of the books. All documents and communications regarding, related to, including, or consisting of marketing and promotion of your books. All documents and communications regarding, related to, including, consisting of your opinions regarding and reaction to Making a Murder. All communications between and among involving Ronald Goldfarb regarding their books, Making a Murder, Netflix, or producer defendants. All documents and communications regarding related to Making a Murder, including not limited to all communications with the producer defendants. All documents and communications regarding related to, consulted, or drafted as part of the Attorney General, Department of Criminal Investigation review of the prosecution of Stephen Avery for the rape of Penny Bernstein, including the 2003 exoneration of Stephen Avery. All documents and communications consulted in preparation for your September 22, 2005 deposition and the civil lawsuit of Avery v. Manitowoc. All documents and communications consulted in preparation for the initial search warrant for the Avery property, as described in Innocent Killer at page 221. All correspondence between among involving James Bogler, Jerry Buting, Lisa Califf, Risa Evans, Norm Gahn, Stephen Glenn, Robert Hennick, Len Kaczynski, Walter Kelly, Tom Kusherick, Ken Kratz, Peg Laudenslager, Kenneth Peterson, Dean Strang, or Dennis Vogel regarding Penny Bernstein, Teresa Hallbach, Stephen Avery, your books, Making a Murderer, Netflix, or producer defendants. Can of worms just got open, Michael Griesbach. Just hope this judge signs off on the subpoena. Alright, protective order. Based on stipulation of parties and factual representations set forth therein, the court finds exchange of sensitive information between or among the parties or third parties other than in accordance with the order may cause unnecessary damage or injury to the parties or the others. The court further finds that the terms of the order are fair and just as the good cause has been shown for entry of protective order governing the confidentiality of documents produced in discovery, answers to interrogatories, answers to requests for admission, and deposition testimony. It is therefore ordered that pursuant in federal and civil statutes, designation of confidential attorney's eyes-only information, designation of information under the order must be made by placing or affixing on the document or material in a manner that only interface with eligibility the words confidential or attorney eyes only. One who produces information, documents, or other material may designate them as confidential when the person in good faith believes that they contain trade secrets or non-public, confidential, technical, commercial, financial, personal, or business information. One of the producer's information, documents, or the material may designate them as attorney eyes only when the person in good faith believes that they contain particularly sensitive trade secrets or other non-public, confidential, technical, commercial, financial, personal, or business information that requires protection beyond the afford a confidential designation, except for information, documents, or other materials produced for inspection at the parties' facilities. The designation of confidential information as confidential or attorney's eyes only must be made prior to or contemporaneously with the production and the disclosure. In the event the information, documents, or other materials are produced for inspection at the parties' facilities, such information, documents, or other materials may be produced for inspection before being marked confidential upon specific information, documents, or other materials have been designed for copying. Any information, documents, or other materials containing confidential information will then be marked confidential after copying, but before the party who was inspected and designated them. There will be no waiver of confidentiality by the inspection of the confidential information, documents, or other materials before they are copied and marked confidential pursuant to the procedure. Portion of depositions, parties, representative, formal officers, directors, employees, agents, experts, representatives will be deemed confidential only, designated as much when the deposition is taken or within 30 days of receipt of the deposition transcript. If the party inadvertently produces information, documents, or other material containing confidential or attorney eyes only information within marketing, labeling it as such, the information, documents, or other material should not lose its protective status, though such production, and the party shall take all steps reasonably required to assure the continued confidentiality of the producing party, provides written notice to the receiving party within 10 days of discovery of the inadvertent production, identifying information, document, or material in question corrected to confidential designation. Disclosure and use of confidential information. Information, documents, or other materials designated as confidential or attorney-free eyes only under this order must not be used or disclosed by the parties or counsel for the parties or any persons identified in the subparagraphs and below any purpose whatsoever other than preparing for conducting the litigation in which the information, documents, or other material were disclosed, including appeals. The parties must disclose information, documents, or other material designated as confidential putative class members not named as plaintiffs. In putative class litigation, unless until one or more classes have been certified, nothing in this order prohibits the receiving party, that is a government agency, from following its routine use in sharing such information, documents, or other material with other government agencies or self-regulatory organizations allowed by the law. Confidential information, the parties and counsel for the parties must disclose or permit the disclosure of any information, documents, or other material designated as confidential, but any other party, third party under the order, except the disclosures may be made in the following circumstances. Disclosure may be made employees of counsel for the parties or when the party is a government entity, employees of the government, who have direct functional responsibility for the preparation and trial of a lawsuit. As any such employees to whom counsel of the parties make a disclosure must be advised of and become subject to provisions in this order requiring that the information, documents, or other material be held in confidence. Disclosures may be only to employees of party required in good faith to provide assistance in the conduct of the litigation in which the information is closed, identified as such writing counsel for other parties in advance of disclosure of confidential information, documents, or other material. Disclosure may be made to court reporters engaged for depositions and those persons, if any, specifically engaged for the limited purpose of making copies of documents or other material. Before disclosure to any such court reporter or person engaged in making copies, such reporter or person must agree to be bound by the terms of the order. Disclosure may be made consultants, investigators, or experts, collectively experts, employed by the parties of counsel for the parties to assist in preparation and trial of the lawsuit. Before disclosure, the experts must be informed of the degree to be subject to provisions of the order requiring that the information, documents, or other material be held in confidence. Disclosure may be made to deposition the trial witnesses in connection with their testimony in the lawsuit in the court and the court staff. Disclosure may be made to persons already in lawful litigation in possession of such confidential information. Attorney's eye only information. The parties and the counsel of the parties must disclose or permit the disclosure of any information, documents, or other material designated as attorney eyes only by any other party or the third party under the oath to any other person or entity, except the disclosures may be made in the following circumstances. Disclosure may be made to counsel and employees of the counsel for the parties who have direct functional responsibility for the preparation of the trial of the lawsuit. Any such employee to whom counsel for the parties makes a disclosure must be advised of and become subject to provisions and order requiring the information, documents, and other material to be held in confidence. Disclosure may be made to court reporters tagged for depositions and those persons of any specifically engaged limited purpose making copies of documents or other material before disclosure to any such court reporter person engaged in making the copies. Such reporter person must agree to be bound by the terms of this order. Disclosure may be made to consultants, investigators, or experts, collectively experts employed by the parties that counsel for the parties to assist in preparation of trial for the lawsuit. Before disclosure of any expert, the expert must be informed and agree to be subject to provisions of this order requiring that the information, documents, or other material be held in confidence. Disclosure may be made to deposition of trial witnesses in connection with their testimony in a lawsuit in the court and court staff. Disclosure may be made to the persons already in lawful and legitimate possession of such attorney eyes only information. Maintenance of confidentiality. Except as provided in the subparagraph, counsel for the parties must keep kept information, documents, or other materials designated as confidential that they receive under the order secured within their exclusive possession and must place such information, documents, or other materials in a secure area. All copies, duplicates, extracts, summaries, or descriptions hereinafter collectively as copies or information, documents, or other material designated as confidential under order, and any portion thereof must be immediately affixed with the words confidential or attorney eyes only, if not already containing that designation. To the extent that it answers the interrogatories, transcripts of depositions, responses to requested admissions, or any other papers filed to be filled with the court reveal or tend to reveal information claimed to be confidential. These papers are proportioned, therefore must be filed under seal by filing with the clerk of courts utilizing procedures set forth in general. If the court filing contains information, documents, or others materials that is considered confidential or attorney eyes only by a third party, the party making the filing shall provide notice of the filing to the third party. Challenges to confidential designation. A party may challenge the designation of confidentiality by motion. The motion must accompany such a motion with a statement required. The designation party bears the burden of proving that the information, documents, or other materials issued are properly designated as confidential. The court may award the party prevailing as any such motion actual attorney fees for costs of interpreting the motion. Conclusion of litigation. At the conclusion of litigation, a party may request all information, documents, or other material not filed with the court received into evidence and designated as confidential or attorney eyes only. Under this order, must be returned to the originating party or the parties so stipulate destroyed, unless otherwise provided by law. Notwithstanding the requirements of the paragraph, a party may retain a complete set of all documents filed with the court, subject to all restrictions of this order, dated in Milwaukee, Wisconsin, August 19, 2021. Exhibit 2. Objections to defendant Netflix Incorporated subpoena to attorney Michael Griesbach. Michael Griesbach, by his attorneys, Mayer, Graff, and Wallace, hereby object to defendant's Netflix Incorporated subpoena for production of documents pursuant to federal and civil. The objections include, but are not limited to, Mr. Griesbach, Counsel record, plaintiff Andrew Colborn, defendant, served a subpoena, ruling 45, Michael Griesbach, and bears information related to the number of books that Mr. Griesbach wrote about his impressions of the Netflix series, Making a Murder, and subjects discussed within the series. The subpoena Griesbach is not a witness in the matter, nor should he be permitted to become one, as simply would not further the matter. Mr. Griesbach's books are simply his own impression of the issues that not bearing on this case. The evidence is not relevant pursuant federal and civil statutes. Mr. Griesbach's books are based entirely on his own impressions of publicly available records. There is nothing which Mr. Griesbach could provide in this matter that would further this matter, and nothing which original evidence provides. The evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is a consequence in determining the action. The evidence which Netflix seeks is not relevant per this standard. Mr. Griesbach relied exclusively on publicly available records, the same records that Netflix series is based on. There is simply nothing Mr. Griesbach could provide which is not already available to Netflix. Thus, nothing that would have a tendency to make fact more or less probable. The requested information is protected because of proprietary nature. The request seeks evidence that is otherwise available. The requests seek information and material that can never be admitted into evidence. These requests are overbroad and unduly burdensome. Mr. Griesbach has no special knowledge concerning the evidence in the Halbach investigation. He relied on publicly available documents, including court filings, court-written decisions and orders, hearing transcripts from court proceedings, including the transcripts from the 6-week-long jury trial, and the transcripts from Netflix Making a Murder. All the evidence is available to defendants without the obvious effort to turn a plaintiff's attorney into a witness for the prejudicial effect. Exhibit 3, which is an email. Dear Counsel, as you know, the firm represents defendant Netflix in above captioned litigation. The litigation on February 10, 2022, Netflix served on your client, Michael Griesbach, a subpoena for production of documents pursuant to Federal Rule of Civil Procedure. The subpoena sought the categories of documents and communications of all which relate to the matters essential to the litigation, namely, the extent to which Making a Murder is subsequently accurate depiction of the events underlying and how viewers, including Mr. Griesbach, reacted to the Making a Murder, and how Making a Murder impacted the reputation of plaintiff Andrew Colborn and all. On February 24th, you submitted objections to the subpoena on Mr. Griesbach's behalf. The objections, and on this basis, Mr. Griesbach has withheld all documents responsive to the subpoena. Mr. Griesbach objects can be categorized as follows. The subpoena seeking information that inadmissibly and not relevant to this case according to the standard by federal law. The subpoena is overly broad and unduly burdensome. The subpoena seeks information that is both public or otherwise available to Netflix. but at the same time protected because of the proprietary nature. And because Mr. Griesbach is now counsel of the record, his first-hand knowledge of the events which underlie making a murder, which predates his notice of appearance in the case, is suddenly beyond reach of discovery. For the reasons explained below, however, these objections lack merit. We therefore write to request that to withdraw the objections and promptly disclose all documents responsive to the subpoena so that Netflix is not forced to bring motion to compel. The objections are waived in light of their reliance of the boilerplate language. These objections consist of boilerplate language without specific factual or legal authority. None of the objections addressed to the subpoena request individually explain why a particular request is improper. The burden rests upon the objecting party to show why a particular discovery request is improper. The burden is only met with the objections state with the specific grounds of rejecting the request, including reasons. The objections ignore the scope of discovery under the Federal Rule of Civil Procedure. Mr. Griesbach objects to the subpoena on the ground that the evidence is not relevant pursuant to federal and civil objection. He also objects that the subpoena seeks information and material that could never be admitted into evidence. Objections, neither object is valid. Information within scope of discovery need to be admissible in evidence to be discoverable. In discovery, with the relevant includes more than what is admissible at trial. Moreover, expansive of that definition of relevancy under the Rule 401, Federal Rules of Evidence, Standard Rule 26, is even broader. Indeed, relevancy is construed so broadly in discovery that it encompasses not just information which itself directly bears on the issue of the case, but also that could lead to other matter that could bear on the issue maybe in the case. The subpoena easily clears this low bar, as shown by even a cursory comparison in Mr. Colborn's Second Amendment complaint and Mr. Griesbach's books. For example, Mr. Griesbach writes of conversations he had with Mr. Colborn regarding the telephone call Mr. Colborn received while working in Manitowoc County Jail. He also writes about drafting an initial search warrant for the Avery property and about the strange coincidence of the timing of Mr. Colborn and James Link's depositions and Mr. Avery's civil lawsuit and the finding of Ms. Halbach's car key in Mr. Avery's bedroom. Also writes about the public reaction to Mr. Avery's exoneration, subsequent arrest for the trial for Ms. Halbach's murder, and how people's opinions toward Mr. Avery didn't evolve. These are but a few examples of many demonstrations why Netflix requests are reasonable, relevant, and proportioned to the needs of the case. As such, there is no bias for the relevance of objection. Mr. Griesbach is obligated to promptly produce all responsive material. The subpoena is neither overly broad nor unduly burdensome. Mr. Griesbach states that the entire overth of the undue burden objection in a single conclusory sentence. The requests are overbroad and unduly burdensome, but wrote unamplified conclusory rectangles of the unduly burdensome, overbroad, vague, and ambiguous, and ineffectual, and every count in the country has held. If Netflix is forced to compel a production of documents responsive to the subpoena, Mr. Griesbach will have to do more. We will have to adequately demonstrate the nature and extent of the claim burden by making a specific showing as to how disclosure of requested documents and information would be particularly burdensome. July 27, 2009, internal quotation marks omitted. The showing typically requires affidavits or other affirmative evidence supporting parties' assertions of burden. Here, Mr. Griesbach made no showing, specific or otherwise, as to how the subpoena would have burdened him. Mr. Griesbach's conflicting objection that the subpoena seeks information that is both public or proprietary itself demonstrates that the objection is invalid. Next, the objections claim that the requests seek evidence that's otherwise available but fail to identify with any specificity which requests seek only publicly available records, nor could they. The subpoena seeks documents uniquely in Mr. Griesbach's custody and control. For example, document request 7 seeks all documents and communications related to making a murderer. Clearly, documents responsive to the request, such as emails Mr. Griesbach sent from private address, are not necessarily public records and may not be available to Netflix through any other source. Similarly, document request 11, correspondence between involving Ken Kratz regarding Teresa Halbach or Stephen Avery. We know that in November 2005, Mr. Griesbach had a private meeting with Ken Kratz, Mark Rohr, and Detective Wiegert, resulting in a decision to draft a search warrant for the Avery salvage yard. See Manitowoc 000066. It is thus apparent that Mr. Griesbach has non-public information that is relevant to this case. What's more, Mr. Griesbach simultaneously claims that he relied exclusively on publicly available records, the same records that Netflix series is based on, and that requested information is protected because of their proprietary nature. These objections are mutually exclusive, and your failure to specify which requests you believe seek publicly available information and which seek proportioned information sufficient to find waiver of both. In any event, purportedly proprietary nature of the information is sufficient ground withhold discoverable material. Attached to B is the subpoena, which was the protection order entered in the case. The protective order contemplates the producing party may designate responsive material as confidential or attorney eyes only with material contains trade secrets, non-public, blah, 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 blah. And the extent Mr. Griesbach's withholding documents based on the incorrect notion that there's simply nothing which he could provide which is not already available to have the documents sought. To the extent Mr. Foreman has declined to produce request documents possession of under control on the ground that they are Burton's possession and a result of separate litigation. His response is insufficient. Burton is entitled to production of the documents in this action without regarding or whether they may have been provided Burton's in the litigation. Mr. Griesbach always has been material fact witness in this case. These objections make several claims that Mr. Griesbach is not a witness in the matter, nor should be permitted to become one. Objections, notably, Netflix has not yet served a deposition or trial subpoena upon Mr. Griesbach. It has simply requested he produce various documents, but respectfully, assertions that Mr. Griesbach is now a witness in the matter plainly false. Mr. Griesbach's role in underlying events long predates the representation of Mr. Colborn in the litigation. Any other suggestion of the contrary is but a feeble attempt Mr. Griesbach to avoid obligation in the fact witness that he has personal knowledge of and relevant discoverable material related to matters at the very heart of the litigation is readily apparent throughout his books. Beyond those examples already provided, The Innocent Killer, which was originally published in 2014, more than a year before the releasing of Making a Murderer, Mr. Griesbach details that he was the first person to discover information about Gregory Allen in the Stephen Avery files of the Manitowoc County District Attorney's Office that directly communicated with the Wisconsin Innocence Project, which was representing Mr. Avery. He was one of the only two people in the room when the DNA analysis at the crime lab delivered the news that Mr. Avery was excluded as a match for the pubic hair recovered from Penny Bernstein, and that he was subpoenaed and actually deposed in Stephen Avery's lawsuit against Manitowoc County. The same lawsuit in which Mr. Colborn was deposed for his role in Mr. Avery's wrongful conviction. All of these monumental points in Stephen Avery's exoneration were depicted in Making a Murderer and go directly to whether the series is in fact truthful depiction of the events. Indeed, Mr. Griesbach himself appears in Making a Murderer and is angled for a more substantial role in the series. All these examples highlight the characterization of the subpoena as an obvious effort to turn a plaintiff's attorney into a witness for potential effect. If only I had not been involved in the Avery story myself, perhaps then I could have simply enjoyed the craftsmanship of the Making a Murderer, Mr. Griesbach, indefensibly, page 9. blatantly ignores the central role Ms. Griesbach played in the saga that is subject to making a murder. Please advise when you are available this week to discuss the matter by phone. We remain open to input whether you are ways to narrow the scope of the subpoena so as to avoid the need to formal motion practice. At this point, however, we see no legal basis for Mr. Griesbach to refuse to comply with the subpoena, and we trust that prior to our meet and confer, you will endeavor to determine which, if not all, the objections your client withdrew. Exhibit 4. This is an email. Miss Walker. Ouch. I have no interest in raising the temperature by making threats or accusations. I have no interest in arguing about who your silence or may silence means. More of the point, I have no intention of authoring an email. I was not until I received your email, which included summary, which I did not agree with, that I felt compelled to respond. I think both of us are better than this. Setting aside the above, may I suggest that the conclusion you draw should be reconsidered. It is our job to understand that to explain the law, court rules, and professional responsibility. Is doing so would resolve in dispute and preclude involvement of the court. I am available, and would such an opportunity, I don't see how it hurts you to share your views on the issues I raised. After all, you have to do this prepare motion, right? Thanks again for your time, and have a great weekend. I will make myself available. Mr. Mayor used the words upshot with intentional because I did not believe it would be productive to further engage with you providing a play-by-play of our call. I would note that you have not actually pointed out anything inaccurate in my bullet points below with regard of your own email. Discard with everything you say. I would have articulate reasons to over the phone have given me meaningfully opportunity to speak, which you did not. It is not through these emails on my channel. Ms. Walker, this looks to me like a very selective summary, some of which just basically factually incorrect. I'm not sure if helpful to explain to indicate more obvious admissions. I asked you how you got around Wisconsin law that protects persons like my client. You had no response, and the fact stated that you knew nothing about it and therefore did not consider this, of course, a very fundamental concern which is directly connected to the other issues consumed bulk of conversation. That, of course, and where I began the discussion by pointing out that a request designed to do exactly what the federal law prohibits, which is turning a lawyer onto the matter into witness. Indeed, there was left the matter by asking you to address the issue. Specifically, what I stated that my suspicion is that via the subpoena you were trying to purposely interfere with Mr. Colborn's choice of counsel by trying to make counsel a witness. You ignored this, just as Wisconsin law issue. I asked you specifically whether the production of any document would end up violating this prohibition. You told me something along the lines of I never thought of that, much like the concern about the absolute privilege under law. Per this email, I'm asking you why you believe that these two bodies of law are absolute prohibition. I did explain that I would like to speak about the concerns I have with my client, but to this I wanted your thoughts on the federal law. So the question to restate is that whether production, including response, that says we do not have a responsive documents, could be construed as a violation of attorney witness prohibition under federal law. I need your thoughts on this because obviously I cannot take any step that could be used by you to support the position that I am why my client has chosen to be a witness and therefore disqualified as counsel. Please address this so we consider the same. Also, from my perspective, I indicate that there is serious problems with the idea that anything my client had to be considered evidence-based because his opinions, ruminations, and other publicly available evidence could not possibly be irrelevant to any issue in the case. I advise that under the definition of evidence, any person, whether that be a court, clerk, jury, judge, anyone that viewed the Netflix prediction would be a witness with evidence. Even more fundamentally, using understanding the law, anyone that anytime looked at any publicly available evidence in any way, shape, form would be considered a witness relevant to the evidence. You did not address the concern other than to ask me if I read my client's books. You further told me that felt my client had a special relationship with the evidence, but when pressed, you refused to explain this. So we want to know how observations, interpretations, and thoughts of evidence could possibly be considered to make an issue of fact in the lawsuit against Netflix more or less true. Again, fundamental in the consideration of the subpoena. Obviously, from the standpoint getting to some agreement above issue is pre-request of substantive response. Share your thoughts on how you can issues be addressed. I indicate that I cannot provide you a response until these questions, particularly federal prohibition and lawyers being witnessed, are addressed. Thanks very much. I enjoyed getting to know you and your team. We would like to move the discussion forward, please. Blah, 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 blah. Your client presently does not plan to produce any documents responsive to the subpoena. He does have responsive documents, at least some requests in the possession, custody, and control. You said that he may not have documents responsive to certain requests. I asked for you to confirm that in writing. I told you Netflix would be bringing a motion to compel, but that you thought your client might, upon further consideration, provide some documents which considered position before bringing said motion. You said you would take the issue under advisement and needed to talk with your client. We asked a date which we could expect the substantive response to your letter. You declined to provide a date. These instructions are an invitation to simply call in if you prefer, or folks were welcome to their cameras off. It's just Mr. Meyer, Friday at 10 works. I'll send a WebEx. I understand that the next time I review the letter. So thanks for making the time to meet and confer this week. Depositions are 6 weeks away and most, so we want to make sure we can get things resolved in the time for those potential needed for court's involvement in the time, something we're trying to account for. Let's see. Mr. Meyer, please see the attached letter which responds to the objections of your client, my Griesbach and above referenced matter. Would like to meet and confer topics set forth letter as soon as possible. Here's my availability over the next couple of weeks, tomorrow and Thursday. Please advise of the free of those windows. I copied all the counsel record in this email except Mr. Griesbach since he is represented party. I will direct communications about the subpoena to you, but given Mr. Griesbach is the counsel of record, I plan to communicate directly with him on all other matters related to this case. Please advise you disagree with their approach. Exhibit 5. More emails. I received ADA Griesbach. I do not know if you heard the live broadcast or perhaps have already had it forwarded to you. Thought it may interest you. The message was intended for blah 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 blah. Exhibit 6. Despite the internal recognition awards, Link and Colborn both come under the fire at the time of Avery's 2007 murder trial. Avery's lawyers Dean Strang and Jerry Boone accused the pair of planting a key in a Hallbox vehicle in Avery's bedroom and planting Avery's blood inside the victim's Toyota sports utility vehicle. Myth in 2002. Link handled a box of unsecured evidence stored next door in the county courthouse building that contents contained vial Stephen Avery's blood. Facts 4/30/2002. Judge grants motion to test fingernail clippings and hair. 6/19/2002, 12:25. Open per Hazelwood's instruction by E.G. Fitzgerald. Closed on 6/19/2002 at 12:27 p.m. Contains Stephen Avery's whole blood sample. Nail clippings, scrapings, and hair was removed per above. See pic below. To be sent out to the lab for testing. The blood vial was returned to the same box storage Manitowoc County House. Reference January 19, 2007, page 134. Motion gone. Fitzgerald represented the amended order of transport of evidence. Nail clippings hair was held up for 4 months due to issues with the exhibit stickers. 9/19/2002, a transmittal of criminal evidence from the complicated by Sergeant Link for the nail clippings and hair. Another document, recipient of physical evidence, also dated 9/19/2002, at 15:47 hours, completed by the noted by Make Salem from the Manitowoc Sheriff's Office took those items to the State Crime Lab. The crime lab designated the items C1, C5, D10, D12, hair and pubic hair, F1 fingernail clippings, and V for shape from Avery. Recipient of the physical evidence signed by Dolores Larson, 9/19/02. Bottom line, Lieutenant Lee completed the form above. Only nail clippings, hair, blood vial was never in his hands, as you state in your article. Update, I see that you recently edited your online version of the article to change it from 2002, Link handled the box of unsecured evidence, to in 2002, to Link has access to a box of unsecured evidence. Thanks for the online correction, although I'm certain won't be publishing corrections to readers of the physical newspaper. Myth, Lincoln Colborn and Remberker remained on the Avery property for several hours that day, but unlike his comrades, Link never signed the police log documenting when he arrived that day. He only signed his name when he left. This is okay, yeah. Okay, Link didn't sign in when he got there because he was before the log was implemented. But there's the very first officer that arrived there, single up, he started to make a record. No one else did in either there prior to 2:25 p.m. when the log was put in place. If you look at the log included in the link, you'll see that lots of names missing. Case in point, Remberker arrived at 10:59 a.m. and left. Neither his sign in or sign out is showing until he returns again from obtaining the search warrant at 3:26 that day. Why? Because it wasn't started until 2:25. Yes, but what you guys don't know is that the Manitowoc started a log first, right when they arrived on the property. It's in that same dispatch log, or yeah. Myth 3. Prior to Avery's arrest, all 3 sheriff's detectives conducted repeated searches of Avery's trailer and detached garage, even though Special Prosecutor Ken Kratz had announced to the media that Manitowoc County would not be involved. Fact. You see how factual their fact is. Manitowoc was never excluded from the investigation. It was decided that Calumet County would lead the investigation. They were the ones initially investigating it as a missing person case because Teresa, the victim, by the way, was their county. However, upon finding the RAV4 in Manitowoc County, it was discussed and decided to have Calumet lead it, and Manitowoc provided resources which included manpower and equipment. Pagel even stated in the local newspaper after Brendan's full confession on 3/106 that resources included manpower, and Mayhem admits again. 11/5/2005, 11:45 a.m. Rieger advised by Sheriff Pagel that the scene, salvage yard, would be turned over to the department under a mutual aid pact from Manitowoc County. 11/05/2005 at 1:04 p.m. Rieger meets with District Attorney Mark Rohr, ADA Michael Griesbach, and Calumet County DA Ken Kratz, and decided they need to apply for a search warrant for the property. Teresa is from Calumet County, so the decision made that let Queso continue the lead investigation. Even though the victim's vehicle is located on a property in Manitowoc County, decisions to have Queso continue the lead investigation due to them may be conflict of interest. Deputy Inspector Greg Shetter. In no way is this done because anyone suspects or worries that law enforcement are trying to frame Avery or potentially plant evidence. This proactive approach and why they are always call county law enforcement with Manitowoc. Oh my God. Myth 4, on November 3rd, 2005, family of Hallbach reported missing a Calumet County Sheriff's official. Nobody has called for Lieutenant Link Strang, argued during Avery's 2007 murder trial, and nobody called looking for him. But the chief detective of Manitowoc County takes it upon himself that night to call Calumet and offer to get involved in missing person investigation and appointments that was kept. That's not a myth. That's not a myth. There's a dispatch call where Link is calling, trying to talk to Mark Wiegert. And it's time-stamped. 11:05, after speaking with Stephen that evening, Sergeant Colborn contacts Greg Shetter, the Deputy Inspector Operations Division, lets him know that Queso is investigating a missing person case and that one of the places that Queso mentioned that the party, Teresa, was at the Avery Salvage Yard. He informed Shetter that he had just left there and was unable to locate the missing person. Shetter suggests that Colborn contact Link to see if he wants any Manitowoc County law enforcement assisting Queso in searching. Lieutenant Link didn't integrate himself into this man, implied he was contacted by Shetter's recommendation after they had contacted Avery Salvage Yard. Well, we know that Sergeant Colborn is the first law enforcement officer contacted by Mark Wiegert. And based on the scarcity of the audio we have been given, if it was in full, we'd have the same thing that Queso has released. We'd have calls that have nothing to do with the case, but it's cherry-picked. But then the next audio calls we have is Greg Shetter being paged. No, not Greg Shetter. Sorry. James Link is requesting Dennis Jacobs and Remaker to meet him at the Sheriff's Department. But anyways, I'll read on. Lieutenant Link contacts Wiegert by phone to get additional information per call from Sergeant Colborn. Wiegert updates Link on the situation. Link informs Wiegert that he would call some people in to assist Queso. We also have Mark Wiegert calling dispatch on Calumet County because he just talked to James Link and advised him that the dead girls Carmen Bootwell, not Teresa Hallbach. We also have Andrew Colborn calling dispatch requesting that information. So all you gotta do is connect the dots. They can lie all they want. The truth is the truth. The next morning, Lieutenant Link does not one better than that. He goes out himself to Stephen Avery's trailer, another officer from Manitowoc. The strain continued. He knocks on the door again as Senator Colborn done the night before, inquiring after Teresa Hallbach again. Stephen Avery. Yeah, that is a myth because Sergeant Colborn was not at Stephen Avery's house. He talked to Stephen Avery at his mother's. Fact. Wiegert from Calumet County contacted Remaker the next morning to go to Avery's. That very may well be Sue, but we don't know that because we don't have their cell phone records. 11/4/2005, 10:20 to 10:35 a.m. Wiegert contacts Detective Remaker and requests that Manitowoc Sheriff's Department try to make contact with Stephen Avery since it was too late that night before. He requests that to try to obtain more info and possibly get consent to search the residence. Well, that's funny because they did contact Stephen Avery the night before, and just so coincidentally, Andrew Colborn doesn't even file a report of any of that happening. They began to leave. We're driving down the driveway, and Stephen was passing their golf cart. It's because they arrived on the property. God knows how long they were there before they ran Stephen Avery's plates on his truck, because then it was overheard on the scanner, and then Chuck or Earl, I'm not really sure, asks him where his truck is. He says, it's at home. Well, your plates just got ran, so mine him hop in the golf cart. And they meet them about halfway. He takes them back to his house, lets them go in, search, and leaves. Link never just went there on his own, and his defense tries to spin it. So again, if you ask John, if you're not willing to print a rebuttal, in the very least going forward, maybe try to get a fair evaluation of what occurred from both sides. Sometimes going against the grain and taking the unpopular stance is the right thing to do for those most innocent people you are easily throwing under the bus. You know, the ones that protect us. We're really now. Exhibit 7. Congratulations. I've been... Okay, this is Michael Griesbach emailing the producers of Netflix. Congratulations. I've been my way through all 10 episodes by Saturday afternoon, and I enjoyed it immensely. I'd be happy to share with you some of the local reaction beyond what has been reported. If you are interested, I imagine you're swamped with media inquiries and other matters, but if you could email me your number and times you're available, I'll give you a call. I'm in the office about 10:30 Central Time, but then on the road to UW-Madison to pick up our daughter for a Christmas break. By the way, I shared most of the views you expressed below in a recent interview with the Post-Crescent. In the end, CGS must be about process, not results. All the best, Mike. Every question just led to more questions, and that's the motherfucking truth. Regardless of what the documentary shows, all the information I've gone over, it just brings more questions upon more questions. Never really any answers. But in the end, we are not trying to provide answers. We just don't have a conclusion. We're really raising questions, and our goal is to promote dialogue about these things. The series became available on Netflix Friday. The filmmakers who were interviewed Tuesday by Post-Crescent Media don't presume to know what happened. Blah, 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 blah. Exhibit 8. This is Michael Griesbach's deposition. They're just highlighting portions of it. Witness, Michael Griesbach, Thursday, 9/22/05, 8:30. Barbara Cohen Joseph. Nash Flutter, Crimson Mechanic. Caption, Avery versus Manitowoc. Appearances, Kelly. Blah, 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 blah. Okay. I don't know why they highlighted the fact that he's 44 years old. I guess I'll just read these. Okay, starts. Question, Mr. Griesbach, would you tell me your date of birth and your age? February 13th. He's Aquarius. Okay, and you're currently an assistant district attorney in Manitowoc. That is correct. Okay. How long have you been in Manitowoc County DA's office? I believe it would be 14 years, since 1991 now. So 14 years, yes. Okay, I understand. We had some testimony by Mark Ward just a little while ago. That was a brief period of time during which you were the district attorney in Manitowoc County. It's kind of a complicated matter. I had been elected as district attorney in 2002 after running for election. I chose for basically personal reasons. Okay, there's no point in me reading this because this isn't the whole damn transcript. They're out there, you guys can read them. But here's a highlighted question. Do you have recollection of any attending meeting with Sheriff Peterson in his office which the matter of Avery prosecution of Greg Allen was discussed? Yes, I do. Mr. Allen was not in the photo array. His physical appearance, height, and weight were such pretty consistent with the victim's description of the assailant at the time. Did you find any? Question. All right. Do you have any recollection of whether Sheriff Peterson produced any files or records concerning Stephen Avery or Gregory Allen at the meeting? Answer. He may have had Allen information regarding the records checks would you have requested the dispatch earlier. Perhaps the photo array and result in 1985. Another question, do you have any recollection throughout the course of the events that since you found out about them September 3rd as to whether or not there was any time of booking photograph from Gregory Allen and made a connection with the 1983 offense subsequently was either lost or destroyed or for some reason disposed of? I have no information about that. Another question, at the meeting that took place in Sheriff Peterson's office with the people that you described to us, was there any discussion about the fact that he had come to the light in 1995 from some sources it was actually Gregory Allen who attacked Miss Bernstein, not Stephen Avery? Ms. Bascom, objection. I don't recall. Well, that's a common answer. Question, and when you say what people were saying in the case, you identify the people that you're talking about. I believe it would have been Colborn. Yep, that's it. That's the end of that. So, y'all got any questions before I go? Well, I got through this faster than I thought it was. I just hope the judge signs off on this subpoena and forces him to turn over all information that he has. But yeah, they say I don't recall a lot. But y'all have a good one.